Hello and welcome to the Minimum Competence episode for Friday, June 14th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have large law firms establishing in Boston, new FERC commissioners reviewing gas projects, a Senate bill for new judgeships, and Visa MasterCard's $30 billion fee settlement in peril. Let's remember, summer afternoon. To me, those have always been the two most beautiful words in the English language. And read today's legal news. A quick note at the top of the show. This morning, the Supreme Court handed down several decisions that will take time to unpack. Most impactful among them is a reversal in a bump stock ban case in Garland v. Cargill. The court ruled that a bump stock does not convert a rifle into a machine gun and cannot be restricted as such. This decision will have significant implications for gun control laws and regulations moving forward, and I expect we'll cover it a little more in detail next week. On this day in legal history, June 14, 1943, the U.S. Supreme Court issued a landmark decision in West Virginia's State Board of Education v. Barnette, profoundly impacting the rights of individuals in public schools. The case arose when Jehovah's Witnesses challenged a West Virginia mandate requiring students to salute the American flag and recite the Pledge of Allegiance, actions contrary to their religious convictions. The court ruled that forcing students to participate in patriotic rituals violated their First Amendment rights of freedom of speech and freedom of religion. Justice Robert H. Jackson, writing for the majority, asserted that compelling students to salute the flag was a form of coerced speech that infringed upon their individual liberties. The decision overturned the 1940 ruling in Minersville School District v. Gobitis, which had upheld mandatory flag salutes. Jackson famously stated, "If there is any fixed star in our constitutional constellation, it is that no official can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion." This ruling reinforced the principle that the government cannot force individuals to express beliefs they do not hold. It underscored the protection of individual freedoms against state-imposed conformity, significantly shaping the interpretation of First Amendment rights in the educational context. The Barnette decision remains a cornerstone in American constitutional law, symbolizing the enduring protection of individual liberties in the face of governmental authority. Large national law firms are increasingly establishing offices in Boston, potentially overshadowing local firms that have operated regionally for decades. This year, Simpson Thacher Bartlett, Paul Hastings, and Blank Rome announced new Boston offices, while Covington Burling, Arnold Porter, and Akin, Gump, Strauss, Hauer, and Feld did so last year. In a notable move, Goodwin Procter recently recruited a 5-partner tech and life sciences team from Cooley in Boston, signaling a consolidation trend in legal services within these sectors. The health and energy industries have remained strong in a sluggish deals market, bolstered by the financial strength of healthcare giants and incentives from the Inflation Reduction Act. The number of law firm openings in Boston has surged over the past decade, with over 40 firms establishing a presence since 2016. This influx includes regulatory-focused firms like Covington and UK-based Magic Circle firms such as Allen & Overy. As large firms move in, regional firms face the risk of losing talent and clients. Despite these developments, the efforts of new big law entrants in Boston remain in their early stages, with firms like Simpson Thacher planning deliberate growth to tap into the city's talent pool. The Federal Energy Regulatory Commission, or FERC, has 3 new commissioners, which could influence the review process for natural gas pipelines and liquefied natural gas terminals. Industry advocates argue these projects are essential to meet rising electricity demand, while environmental groups push for rejection due to the long-term climate impacts of fossil fuels. The newly confirmed commissioners, Democrats David Rosner and Judy Chang and Republican Lindsay See, joined FERC at a critical time. With Commissioner Allison Clement's upcoming departure, FERC will regain a 3-2 Democratic majority for the first time in 18 months. Historically, FERC's decisions on natural gas have been contentious, with a 2022 policy to scrutinize gas projects leading to the end of former Chairman Richard Glick's tenure. The new commissioners have indicated a focus on gas infrastructure despite past environmental concerns. Chang, for example, moderated her previous stance against new gas pipelines during her confirmation hearing. FERC's decisions are crucial amid growing electricity demands driven by factors like artificial intelligence and increased manufacturing. Natural gas consumption is at record highs, and new power generation, particularly from gas, is necessary to meet future needs. However, permitting reviews and litigation have slowed the expansion of pipeline capacity. Industry experts stress the need for regulatory certainty to align infrastructure with demand, a sentiment echoed by the Interstate Natural Gas Association of America. The new FERC commissioners face the challenge of balancing these competing interests as they begin their terms. On June 13th, the U.S. Senate Judiciary Committee advanced bipartisan legislation to create 66 new judgeships in federal district courts across states like California, Delaware, and Texas. This marks the first major judiciary expansion in over 3 decades. The committee's unanimous 20-0 vote moves the Judges Act to the full Senate for consideration. If enacted, it will be the first comprehensive authorization of new judges since 1990, addressing long-standing requests to manage rising caseloads in 25 district courts nationwide. The last time new judgeships were created was in 2003, but efforts to expand the federal bench have since stalled due to partisan concerns. The current bill mitigates these concerns by incrementally adding the new judicial seats over 10 years, starting in January 2025, after the 2024 presidential election. This phased approach aims to prevent any single party or president from gaining an advantage. Democratic Senator Chris Coons, a co-sponsor of the bill, emphasized the urgency of expanding the federal bench to address the growing backlog of court filings since 1990. The Judges Act aligns with recommendations from the Judicial Conference seeking to add judges in districts facing a genuine crisis of workload. U.S. District Judge Robert Conrad expressed the judiciary's appreciation for the Senate's efforts. The judiciary currently has 677 authorized district court seats and 10 temporary ones, which another Senate-passed bill aims to make permanent. Initially opposed to adding more judges, Republican Senator Chuck Grassley supported the bill after amendments spread the additions over time. The Judges Act now plans to introduce the 66 new judgeships in 5 stages through 2035, with 3 temporary judgeships in Oklahoma. A companion bill is pending in the Republican-led House of Representatives, backed by Representative Darrell Issa, chair of the House Judiciary Committee's panel on courts. The proposed $30 billion antitrust settlement between Visa and MasterCard to limit credit and debit card fees for merchants is in jeopardy. U.S. District Judge Margot Brody in Brooklyn indicated she is likely to reject the settlement, citing her intent to write an opinion detailing her decision. Both Visa and MasterCard expressed disappointment, describing the settlement as a fair and appropriate resolution to a nearly 19-year-old litigation. Announced on March 26, the settlement aimed to address most claims from nationwide litigation, with small businesses making up over 90% of the settling merchants. Businesses have long argued that Visa and MasterCard swipe fees, which totaled $172 billion in 2023, are excessive and that the card networks illegally prevent them from steering customers to cheaper payment methods. The settlement proposed reducing swipe fees by at least 0.04 percentage points for 3 years, capping rates for 5 years, and removing anti-steering provisions. However, objectors, including the National Retail Federation, criticized the settlement as insufficient, arguing that it would still allow Visa and MasterCard to control swipe fees and prevent future claims by merchants. The case, known as In Re Payment Card Interchange Fee and Merchant Discount Antitrust Litigation, is being heard in the U.S. District Court for the Eastern District of New York. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we are continuing our stated aim to start closing out the week of shows with a musical piece to feature. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by John David Davis. John David Davis, born the 22nd of October in 1867 and died the 20th of November in 1942, often known as J.D. Davis, was an English composer born near Birmingham. Although he was born into a musical family, Davis was initially sent to Frankfurt to prepare for a commercial career. However, his passion for music led him to study under Hans von Bülow. Davis completed his education in Germany before furthering his studies in Brussels with Leopold Wallner, Arthur de Greef, and Maurice Kofferath. Upon returning to Birmingham in 1889, Davis began teaching music, notably at the Birmingham and Midland Institute from 1893 to 1904. In 1905, he joined the Guildhall School of Music as a professor of harmony and composition, and also served as a professor at the International Conservatoire in London. In 1919, Davis married Helen Winifred Juta, the daughter of South African Judge Henry Juta. The couple lived in Earl's Court, London, before moving to Lisbon in 1936. Davis passed away in Estoril, Portugal in 1942, and his wife later returned to South Africa, where she died in 1952. This week's closing theme is John David Davis's evocative piece, Summer's Eve at Cookham Loch, Opus 50. Composed in 1916 for the London String Quartet, this work captures the serene beauty of a summer evening at Cookham Loch. Known for its lyrical quality and gentle atmosphere, Summer's Eve at Cookham Loch offers a tranquil auditory experience. The piece, also known as an idyll for string quartet, demonstrates Davis's ability to paint a vivid picture through music. Its delicate melodies and harmonies reflect the calm and reflective mood of a summer evening by the water. This composition stands as a testament to Davis's skill in creating evocative and picturesque musical landscapes, making it a fitting and soothing choice for this week's closing theme. Without further ado, Summer's Eve at Cookham Loch, Opus 50. Enjoy.